What is the one? Where I have clearance, Mr. Nidumana? Eight? 1-8.
Where it's 60, base 60. So, the machine issue
One.
issue everything dangerous, Shirani, polygon method account the procedure including to exhibit C and exhibit G or the or this. Later, etc. or to see the method, etc. And the portion results in figure and the definition. To declare that the mechanism demonstrated of the MRP and the destination starts to demonstrate the body, the demolition structures, commercial. We should recollect citizen houses deprived of its means of livelihood, based entirely on an inquiry and the answer given by various possible responsibilities. The issue of the nature manifests directly the state legal adjustment better mechanism for litigation of dispute the program of the legal certificate. Identify creating independent judicial tribunal for judicial bodies as excellent. Man-made latest on subordinate conditions to be state or in corporate form.
Now, what are these orders of 30th July and 21st August?
That is the direction from the government. So, you see, the order by which is final.
What page is that? What page is that order?
And 226. And because of this worship, go to the government or this country. That's very far extent. In a power of details, far from for instance.
Sorry, what?
489.
489.
Yes. In a power of details, a small structure, operating some blocks to the back, and then when considered as small structure, actually it is a rustic village. A small structure.
These are the structures they want to demolish. These are the structures you demolish.
Company by for the direction and based on the character area and now
Where is the order?
They produce at page. They should page
226.
Sorry, there's a translation I have produced.
Translation you have produced where?
So translation is what should not be produced in yes. They put the element.
239.
They order. Translation is today for very okay. Starting from
One minute. Who was respondent number 8 in the PI? Who? You are who?
I am a spiritual person. I am a spiritual person from Ahmedabad related to various environmental issues.
And who was the petitioner in the PI?
I was the petitioner.
No, so who was respondent?
Number 8 was our petitioner.
Respondent number 8 was.
Yes. be very phenomenal.
1 minute. Now, after this order, which is the other order, exhibit E, no?
Yes, that is to take the demolition of this method. Demolition of this method. Yes.
Where is that?
Exhibit F. Exhibit F.
Exhibit F.
Yeah.
Page
So we call it.
480.
Yeah.
So this is a consequential order.
Yeah. Okay. For it's a construction to be demolished by the government of 25, 8/2025. And there's the command in 6F. I totally office secretary. And he is an expert in illegal structures and issues.
Okay, now this order that is passed by the collector of Algar, That is subject matter of challenge.
Appeal.
Where is that appeal?
Appeal is about a page here. Yes. So 277 to 460.
277.
277 multiple. 277 to 460. And in order of the application for injunction from 470, 460 to 470.
Now what has happened to this appeal?
It is very the order is taken 30th of July, was communicated to us on 8th.
Which order?
The original order is taken 30th of July 2024.
The order of the collector Palgar.
Yes.
That is dated what? 30th July.
30th of July 2025.
And was communicated when?
On it is only on the 8th. Also, 5th of and the certificate was obtained on 7th of August.
Okay.
And we were surveyed on 20th of August.
And in the appeal, have you filed any application
Yeah,
for state?
It's with the 463.
463.
463.
This is an application for state.
Yes. Maybe
Okay. Yes.
but for the organization and for the being integrated with the order Lord, the entire structure is deals of any permission, even any permission. Because this falls within the territory of village, where we were under section 18, corporate also is correct. There was no application.
Section 18 of the
MRD. MRD given a section 18 8 to 46. Only after completed application for permission in record. Another UCPR also, under the operating is correct. And what they are, we were sitting at the application. When the construction was going on, but as a created person, we were kept on calling all the authorities with photograph, saying that there is no permission at all. All that is finding upon is an agency by the Gram Panchayat. Gram Panchayat cannot be something more than that. So permission to be obtained by corporate. Ultimately, after calling that toward finally to the orders passed, while the purchaser stopped the construction, he did not stop. He consulted over 23 commercial units and illegally were permitted them to occupy. That is one. Second part is this, without the state, Maharashtra State Highways Act, without doing the notification under section 7, which prohibits any construction within the line of control. By virtue of this structure, the entire limit
that 50 meters from the center of the highway.
But he has constructed 21 meters from the middle of the road. So you see the same road, which takes Barbal Bazar,
Where is the notification?
Yes, for that, what should be fine. Page 186.
Page
Page 186.
186.
Actually. No, I really clear party. If he's not, I qualify as cautious. He has no lockers. I'm quite extremely what I know. I have he said I'm qualifying as cautious. That's the only reason he has been made a party. He has no lockers. Absolutely no lockers. Absolutely no lockers. This is a grossest abuse of judicial process. If you are from the state, you will represent nobody. You are nobody, you have no right to law. You have no right to come. That doesn't mean that you have silent report. Page 185. Occupancy is working. Yes, but it is scheduled. So in the middle there is Imara Desha, the line of control. One is Nagari and Abduli Marga, and the other is Managari Marga. That is Project 186. Managari Marga is not urban area. in which
which serial number are you reading?
Product 3. Product first I am reading the caption. Rattata Darja, Imana Trisha. Imana Trisha, in there are two products. One is Hungarian Authority Park, which is not clear of concern. And one is Unagri Park, that is non-urban area. In which please see product paragraph 3. Product this is Rajan Mark. Second product state level 130. Product in middle say product this is unfortunately not properly typed. रस्त्याच्या मध्याभागून 37 meters from the middle of the road. Particularly after inspection, it was found that it's about 21 meters away from the middle of the road. And thereafter, PW and the team were to maintain the road. Were the issue notice provision for removal. He has not filed the appeal against that. That order is also there. So there are the two things. The first is impeding structure by which now there is an extension of road from the entire Dhanur towards station towards Sarudina, where the entire fence street is being developed by about 30 feet road, in the council and thereafter nothing intention. So this is the same road which we are running to Biotel. Now by virtue of this and several other different structures against which the council is taking action, whether this petition is filed. But we are not filed, in we are not the honorable chief justice said that let the collectors explain whether there is any illegality or not. He was heard on 5 to 6 occasions. He submitted all the documents, they were fully heard. Now nothing remains here. Remember, after filing the appeal, there it is a problem shopping. He could not get any stay there. Therefore, this petition is filed. But I am a director, but I am not served.
So he has filed the appeal only on 20th, along with the stay application. So let that stay application be heard at least. We are not saying
be heard. But I quite see that. It gives from any permission.
No, you may be right at the end of the day, but at the end of the day, if the party has filed a stay application, the authority before whom the stay application is filed in the appeal can say that look, there is no, the trial court has held, I mean the lower authority has held that he has got no permission whatsoever, and therefore no prima facie case is made out for stay and reject the stay. But it can't be that the party is condemned unheard. That is all that we are saying. At the end of the day, he may be a person who has carried out completely illegal construction. All that we are saying is that, and just now Ganesh festival is there. In the meantime, if you go ahead and demolish, correct.
Despite of that, one of the not filed something for the minister ways to make the forward. That's the first one. Second aspect, the order started by
to be fair to them, the order was communicated to them only on 5th of August. So he can't file an appeal until he gets a copy of the order. No, how is he supposed to file the appeal?
Maybe the petitioner was well aware of the proceedings that were conducted. From 30th, well prior to
Yes, of course.
The second thing is that there was a proper investigation and survey conducted as per the direction of the dishonorable court. The petitioner was well aware of those proceedings. He was present and he signed on the road now of resolution.
Yes, he's not disputing all that.
No, he's not, but still he brought his prayers or the ground worship. He realized that what is being alleged at this moment, at this stage, is the high-handed action of the state government, which I am taking objection to. That is the first article.
Forget what is said in the petition.
Yes.
All the extortionists.
All these things you have taken from one ear and take out of the other. The most important thing is that should a party be condemned unheard or not? That is the only question.
Doubt whether the appeal is maintained or maintained.
Yeah. Very good. No question.
The entire Canada High Court Association was constructed without information. Whenever there is a illegality, they are talking about Plastic Julian, plastic Julian can be equivalent. So the applicant should not.
We are not getting into the fact whether it is illegally constructed or not. That is not the remit of our jurisdiction.
It's okay.
That is for the authorities to decide. All that we are saying is one authority has decided that it is illegal. He was heard, principles of natural justice, etc. have been complied with, there is no difficulty. He has filed an appeal from that. It is filed on 20th of August. From the date of communication of the order, within 15 days, he filed the appeal. He has also filed an application for stay. In the meantime, if you are demolishing structures, then that entire appeal becomes infructuous. That is the whole problem.
It is not very sure for interest in the structure because now he sees the petition, he says that all those people also be pure.
No. There is no question. Mr. Nidumbara, we are making it very clear to you. In the appeal only you will be heard.
No, I okay.
Because you have been, according to them, responsible for the illegal construction.
I something first principle. I will speak for myself. He is somebody who has no right to speak for everybody. Who is he? Who is representing? He is a letter. See, there is something who can represent the corporate. He has to represent the proceeding. Section 91 of the
No. Whether rightly or wrongly in the PI and the Honorable Chief Justice has passed an order. Now we can't go behind that.
We have very application. Here has to represent the proceeding. Follow the principle of order section 91 of CPC.
Maybe so, but we are saying now there is already an order passed. Rightly or wrongly, that order binds us. We can give you, Mr. Nidumbara, what we plan to do is this.
As per the notification, only 5 meters are required in the wait more 5 meters. This is not correct, sir. There is also one by PW saying that you are
all this, Mr. Nidumbara, you argue before the
Yes.
appellate authority. What we propose to do is this.
Yes.
We propose to say that the authority, the appellate authority, which is the appellate authority, respondent number?
The state office, secretary office, state office.
If either meeting the state or because under this kind of law, and that's the case, then because that's the right now,
So you tell us, yeah. The longer time you take, the happier Mr. Nidumbara will be.
right. So what I'm requesting for expansion passes order because if you might, for example, if the particular violated remains present because the appeals authority or basically they gave some consent.
Correct.
And there are the orders be passed which is a period of 4 weeks after the
Fair enough. Fair enough.
But if you break laws of the last year said, and the law is like a spider. It's not poor people, small people. That's just the thing.
Mr. Nidumbara, you've seen the construction you carried out. You are not poor. The people you may have rented it out to may be poor, but you are certainly not poor.
Look at this.
Yes, you've seen that. That's why we are saying.
Take it out of the car. Take it back in there.
Take down.
Take it back in there.
Well, the petition is filed challenging the order dated 30th July 2020 2025 and the consequential letter dated 21st August 2025 issued by the collector from Palghar as well as the Tehsildar Dhanu. By the order passed by the collector on 30th July 2025, the collector came to the conclusion that the construction erected by the petitioner on what is the land? What is the description of the land? Where is the land? No, what is that? Gut number 27/2, measuring approximately 1561 square meters in village Ashagan, Taluka Dhanu, district Palghar, is wholly unauthorized. The collector was called upon to decide this issue. Into bracket you write whether the construction erected by the petitioner herein was illegal or otherwise, pursuant to orders passed by the division bench of this court in PIL. What is the 105? Sorry? Page 105. Page 105. Pages. Where is that order? Yes. PIL order? In Public Interest Litigation number 105 of 2024. Page 222. In that PIL, an order was passed on 22nd April 2025. It is pursuant to the directions given in the PIL that the collector undertook the exercise to examine whether the construction erected by the petitioner was illegal or otherwise. After hearing all parties, including the petitioner hearing, the collector came to the conclusion that, inter alia came to the conclusion that the construction erected by the petitioner was unauthorized because no permissions were taken from the competent authority and only the permission of the Gram Panchayat, only the NOC of the Gram Panchayat was obtained by the petitioner. New paragraph. Being agreed by this order of the collector dated 30th July 2025, into bracket you write, and which was communicated to the petitioner on 5th August 2025, don't bracket. The petitioner preferred an appeal under what section? Appeal is filed under what?
56(2). 56(2).
Under section, just give us the MRTP. Filed an appeal to the state government under section 56(2) of the MRTP Act. MRTP Act, Common 1966. Along with the appeal, the petitioner also filed a stay application. Correct?
Yes.
The main grievance in the present petition is that while the appeal and the stay application are pending and have not been heard, the authorities are threatening to demolish the structures of the petitioner. It is in this light that the matter has been urgently moved before this bench today, as the regular bench taking up these matters is unavailable. We have heard Mr. Nidhumbara from the Learned Counsel appearing on behalf of the petitioner, as well as the Learned Counsels appearing behalf of the state as well as respondent number 8. Respondent number? 10. Respondent number 10. To bracket you write the original petitioner in PIL 105 of 2020. 2020. Sorry?
This is good. This is good. You are doing for right.
Of 2024. We are of the opinion that since an appeal has already been filed along with the stay application by the petitioner before the state government, we are of the opinion that at least the stay application of the petitioner be heard expeditiously. Full stop. We accordingly direct that the stay application filed by the petitioner shall be heard within a period of 6 weeks from the date of uploading of this order on the High Court website. Full stop. To take this process forward, we direct that all the concerned parties, especially the petitioner, shall first appear before the concerned authority hearing the appeal on 8th September 2025, when the said authority shall give all further directions as to how it wants to proceed with the hearing of the stay application and or the appeal. In the meanwhile, we direct that no coercive action shall be taken against the petitioner for demolition of its structures. We also direct that the petitioner, in the meanwhile, shall not create any third-party right, title, or interest in the structures erected by him on cut number 27/2.
Electricity connection also disconnected.
Electricity connection has been disconnected.
No, they are totally disconnected. No, that is already disconnected.
So once we said no coercive action, that means nothing.
And Russia, the reason why I say Kerala, there's a decision of the authority, the government is appealing to Punjab Raj. So,
To what tribunal?
Punjab Raj. The decision of the authority, the decision demolished is available to the government, and the decision of the government is available to
But that's not there, unfortunately, in Maharashtra.
No, Punjab Raj. That is why I made it all prayers. If you are not agree, you have to consider. I only see. You ensure the nature of national directly the state to bring in a just and fair mechanism for ratification of dispute.
That all we'll consider in your next writ petition. Yes. It is needless to clarify that we have granted this limited stay without examining the merits of the matter, which shall be decided by the appellate authority on its own merits and in accordance with law. All contentions in that regard for all parties are expressly kept open. The writ petition is disposed of in the aforesaid terms. However, there shall be no other rest of us. Yes.